hearing on the application of Secretary of State for Warby and Edis versus Timson.
Sheldon.
My Lord, good morning.
Thank you very much for the timetable, which was helpful. Just one question on this. I wasn't sure why Mr. Coppell, for the intervener, is having the last word as a reply.
You may want to hear from Mr. Coppell.
Well, there was some discussion between the council as to whether I should be going for Ms. Richards because I'm responding to her respondent's notice points, and we compromised in the end by me going first because I'm supporting the appeal, and then just in case she raises some new points in response to my arguments, which are reply points, then I would be given that opportunity. But it may not be necessary.
But she'll be dealing with her respondent's notice when she makes her submissions. That's
right. But on the timetable, I've got to make my points on her respondent's notice before she does.
Well, we'll see how it goes, but it's quite unusual for an intervener to be having a last word at. We'll see where.
Well, my Lord, I would have been content to go after Miss Richards, so that Mr. Sheldon would have the last word as the appellant, but that wasn't satisfactory to Miss Richards, and so we.
Well, there's a risk we'll spend longer talking about that than you want for your reply. Thank you. Yes, Mr. Sheldon.
So, my Lord, I appear in this case on behalf of the Secretary of State for Work and Pensions, with Catherine Apps, King's Counsel, and Gethin Thomas. Jason Coppell, King's Counsel, appears for the interested party, Severn Trent Water, and Jenny Richards, King's Counsel, and Tom Royston appear for the respondent, the claimant below, Miss Timson. My Lord, just in terms of some housekeeping, just to make sure that we have all the right documents, there should be a core bundle. And I know some of you have electronic, some of you may have hard copy. I'm here with both. Core bundle, a supplementary bundle, a very short second supplementary bundle, and an authorities bundle. It was noticed that the page references in the replacement skeletons were a couple of pages out, and so you've received fresh replacement skeletons, so hopefully that will coincide with the various page numbering. And you should have my skeleton argument and my reply to the respondent skeleton argument, and then a supplemental note from the appellant. You should have the Severn Trent's skeleton argument, and then you should have a respondent skeleton argument, and then a respondent skeleton argument in response to the Severn Trent's skeleton argument. So quite a few documents, but hopefully you have all of those. My Lords, I have to hand up, depending on how good your eyesight has been in terms of, in case you've been looking at the spreadsheets that are in the bundle. We've brought along larger versions of them so that when we go through them, it might be easier for you to see.
As far as the bundles are concerned, can I just understand, electronically, I have an updated supplemental bundle.
Yes.
And then I have something that's described as second supplemental bundle.
Yes.
Yes. And so
that's what you should have. So there was an updated supplemental bundle, and then there was an additional few pages.
Thank you.
But my Lords, if I can just hand this up for you just to have, this is basically a replication of what you already have in the bundle, but easier to read, although maybe not that much easier to read. So, my Lord, this is an appeal from the decision of Mr. Justice Cavanagh, handed down on the 23rd of September 2022, and with respect to costs on the 14th of October 2022 in his ruling on consequential matters. The substantive appeal concerns the framework adopted by the Secretary of State for determining third-party deductions, which I may occasionally call TPDs, but third-party deductions, from what are known as legacy social welfare benefits. And legacy benefits are income replacement benefits, which are not universal credit and mostly predate universal credit. So just for you to be clear, this case is not concerned with universal credit. And the statutory scheme that we are concerned with is essentially set out in Schedule 9 of the Social Security Claims and Payments Regulations 1987, which I will call the 1987 regulations. And the judge's order was that the claim for judicial review is granted to the extent that it is declared that the defendant's decision-maker guidance and overview relating to third-party deductions from legacy benefits for water and fuel debts under Schedule 9 is unlawful because by implication and omission, it does not make clear that claimants should be offered an opportunity to make representations and or provide relevant information to the decision maker before a TPD decision is taken. There are 6 grounds of appeal, but one of these, which was appealing against Mr. Justice Kavanagh's refusal to grant an interim stay, is no longer in issue because a stay was granted by this court on permission. And unless you wish me to address you further on that matter, I do not intend to do so.
No, thank you.
The interested party supports the appellant's appeal. The respondent, Ms. Timson, opposes the appeal, and she has put in a respondent's notice. Part of that notice constitutes a challenge to factual findings and evaluative judgments reached by Mr. Justice Cavanagh. And so, although we don't need to get into the terminology, probably strictly speaking, it should have been a cross appeal. But we take no issue with that. But
Well, not unless she was asking for a different order.
well, she's asking for different findings to be. Basically, she's seeking to overturn some of the findings of the judge, and it may
That's
well.
what you do in a respondent's notice.
Well,
It's only if you're seeking a different order you need to cross appeal.
my lord, I won't take this any further. My lord, in terms of the structure of my submissions, just to let you know where I'm going to deal with a background to the statutory scheme, provide a brief factual background, take you through some of the key aspects of the judge's decision. Then I'm going to address you on the law on fairness and Tameside, which is to do with obtaining information. And I'll be making submissions that Mr. Justice Cavanagh erred in his legal analysis by wrongly applying the approach set out by Lord Justice Underhill in a case called Balajigari, rather than the approach of Lord Sumption in Bank Melat when dealing with post-decision representations. But also, the learned judge erred with respect to the particular statutory scheme and the facts in his application of whatever test should have been applied. And in brief, our submission is that fairness, principles of fairness, do not require the Secretary of State to invite representations as to the making of a TPD in advance of making a TPD in every case. Furthermore, we will submit that Tameside test is satisfied. That is a Wednesbury unreasonableness test, and we will say that the judge should not have found that it was Wednesbury unreasonable for the Secretary of State to have relied on the materials that were available to him. And as part of the argument, we will be submitting that the learned judge made 2 perverse findings which infected his decision on fairness and Tameside. I'll then deal with an error in the judge's approach to policy challenges. That is, whether the wording of the overview and decision makers guide documents is unlawful under the approach to policy challenges set out by the Supreme Court in the case of RA. And then I'll deal very briefly with an appeal in terms of costs. So, my lords, if I can start with a brief background to the statutory scheme. The statutory scheme for TPDs, as at the time of the judgment, is set out at paragraphs 31 to 51 of Mr. Justice Cavanagh's judgment, and you have that judgment at tab 9 of the core bundle. I'm sure your lordships have had an opportunity to have a look at that, but pages 97 to 100 is where the statutory scheme is set out. And I don't take issue with the way in which it is described, but I think it may be worth just going through it with you so that you have the feel for the statutory scheme. Under the statute, the relevant statute, which is the Social Security Administration Act 1992, which you find in your authorities bundle at page 6, regulations may provide for the circumstances and manner in which payments of such a benefit may be made to another person on behalf of the beneficiary for any purposes, which may be to discharge in whole or in part an obligation of the beneficiary or any other person. So there is a power to make regulations to provide for deductions from a benefit so as to discharge the benefit recipient's obligations to that third party. We believe that the original source of this power is derived from a scheme back in 1978, but I can't give you confirmation of that. But the current scheme, the current power is in the 1992 Act. The relevant regulations are the 1987 regulations, the Social Security Claims and Payments regulations, as have been amended from time to time. And, my lords, if we turn up the authorities bundle, behind tab 3, page 19, one can see that regulation 35 provides that deductions may be made from benefit and direct payments may be made to third parties on behalf of a beneficiary in accordance with the provisions of Schedule 9 and Schedule 9B. And it's to Schedule 9 that we have the core details that are relevant to this case. And just at this point, I should refer you to the fact that below, the respondent, the claimant below, didn't challenge the scheme itself. They didn't challenge the regulations themselves. They challenged the way in which they were being operated or exercised by the Secretary of State. My lords, on page 23, so we're now looking at paragraph 9, sorry, Schedule 9, and then paragraph 1, which is an interpretation section. There's a number of different different definitions there. At the very bottom of page 23, you may see a reference to specified benefit. And that explains what we're concerned with. These are the benefits from which the deductions can be made. And you'll see, for instance, income support, at A, and then at E, relevant to this claimant is employment and support allowance. And for those of you who may not be familiar with employment and support allowance, that is a benefit which is designed to provide money to help with living costs for those who have a disability or health condition that affects how the individual can work. And there will be different categories of recipient, those who the Secretary of State reasonably considers cannot work or has difficulty working, and those who are trying to be put back into work. Now, those are the specified benefits from which a deduction can be made. At paragraph 2, page 28 of the bundle, we have the list of liabilities to which the benefit can be paid over to discharge. So you see the specified benefit may be paid direct to a third party in accordance with the following provisions of this schedule in discharge of a liability to the beneficiary or his partner to that third party in respect of, and then there's a list of liabilities, potential liabilities, including housing costs, and at D, fuel costs, E, water charges. So there is a power with respect to this to deduct with respect to this particular benefit, with respect to these particular debts. Then the detail with respect to fuel costs, my lords, you find at page 43 in paragraph 6 of Schedule 9. And this provides that subject to subparagraph 6 and 6a in paragraph 8, and we'll come on to paragraph 8 shortly, where a beneficiary who has been awarded the specified benefit or his partner is in debt for any fuel item, to an amount not less than the rate of personal allowance for a single claimant aged not less than 25, and continues to require the fuel in respect of which the debt arose, and I'll come back and explain what all those things mean. The Secretary of State, if in its opinion it would be in the interest of the family to do so, may determine that the amount of the award of the specified benefit, the amount deductible, calculated in accordance with the following paragraphs, shall be paid to the person or body to whom payment is due in accordance with paragraph 2.3. So there has to be a debt already. So you haven't paid your fuel bill, electricity or gas, and you haven't paid that up to at or above an amount which is equal to what's known as the rate of personal allowance for a single claimant over the age of 25. That's around, I think, currently £73.10. So you owe some money, and you have a continued need to use that fuel. So you have there's an ongoing usage. In those circumstances,
obviously, with the fuel in respect of which the debt arose, you've already used.
So you've used in respect of the debt, but then it goes on to say, and you continue to require the fuel in respect of which the debt arose. So
either gas or electricity.
Either gas or electricity. Not that you're trying to use the stuff that you're already in debt for. It's the concept.
I understand what it must mean. Seems to be slightly strange wording.
But my lord, I see what you're saying, but the fact is this: where there's a debt in respect of fuel, electricity or gas, and you continue to require electricity and gas, then the benefit can be deducted from.
Just a point of interest. Does it cover oil as well? I don't think it's relevant.
I'll have to check, but none of this. We haven't considered.
We're not bothered with it in this case. That's wonderful.
But it can be deducted if in its opinion, so if in the Secretary of State's opinion, it would be in the interest of the family to do so. Then at 6.2, they refer to what can be deducted. So the amount deductible shall, in respect of any fuel item, be such weekly aggregate of the following as is appropriate. And A is in respect of the debt. It's a weekly amount equal to 5% of the personal allowance. So you can deduct essentially 5% of the... I'm told it's not oil, my lord. It's not oil. 6.8. 6.8 defines fuel item. Yep. And that doesn't. 6.8.
6.8, thank you.
So over the page.
Yeah.
Gas and electricity. That's the definition of fuel. But the amount that can be deducted shall, in respect of any fuel item, be such a weekly aggregate of the following. So in respect to the debt, it's 5% of the personal allowance for such period as is necessary to discharge the original debt. And then at B, which is to do with ongoing usage, except where current consumption is paid for by other means, for example, prepayment meter, an amount equal to the estimated average weekly cost necessary to meet the continuing needs. So there's an assessment of the expected ongoing costs. And then at 6, subject to paragraph 8, a determination under this paragraph shall not be made without the consent of the beneficiary if the aggregate amount calculated in accordance with subparagraph 2 exceeds the sum calculated in accordance with paragraph 8.4. So there will be a level at which consent of the benefit claimant is required before a deduction can be made. With respect to water, you find that at regulation paragraph 7. Where the language is the same, save for some additional wording at 7.2, which refers to only if the Secretary of State is satisfied that the beneficiary or his partner has failed to budget for those charges and that it would be in the interest of the family to make the determination. So the failure to budget language appears there, doesn't appear with respect to fuel. The learned judge below said it didn't make any difference to the analysis.
There's one other semantic difference, which is that this paragraph 7.2 sets the threshold at is satisfied, whereas 6 it talks about in the opinion.
In the opinion of.
No one suggests there's any difference between those.
There's no difference. It's presumably because of a historical place where they came, but there's no difference.
No.
Judge below said that this additional language about budgeting didn't make any difference to the interpretation. We agree, although I believe Mr. Koppel may make some submissions on that from his perspective. If we turn to regulation, so paragraph 8, which is on page 58 of the bundle, one can see the heading there, maximum amount of payments to third parties. And what needs to be borne in mind here is that this may not be the only TPD that is being sought, or where the decision is being made. There may be a TPD with respect to housing costs or some of the other matters. And so what paragraph 8 is dealing with is there needs to be consent if one gets above a particular threshold, either individually for that TPD or when it's aggregated with other TPDs. And the effect of that is to require consent in those circumstances, but consent is not required if it's under the particular threshold. And so 8.1 is dealing with debt. So what one owes for past here fuel or water, but it could be any of the other matters which fall within the scheme. And the maximum aggregate amount payable shall not exceed an amount equal to 3 times 5% of the personal allowance. And then the maximum amount shall not with the, then 2, the maximum amount payable under, and that's basically the debt plus the ongoing usage, shall not without the consent of the beneficiary exceed a sum calculated in accordance with subparagraph 4. And there we have the sum referred to in subparagraph 2 is where the claimant or partner does not receive child credit, 25% of, and then you'll see in respect of different benefits, something called the applicable amount for the family. And you'll see that in respect of income support, and also in particular for in the case of an employment and support allowance, the applicable amount for the family as is awarded under other regimes. So that is part of, in respect of employment and support allowance, part of the benefit that this individual, this claimant received, but not all of it. But it's in a sense, it's the basic amount that you receive under that particular benefit. And you have to give consent if the TPD will take away more than 25% of that amount, whether alone or with the other TPDs. So what that means is the Secretary of State can only take away a certain amount without your consent, and the individual benefit recipient will have, in any event, 75% over which they will have autonomy and control. They cannot be, in a sense, required to have the TPD in respect of that.
Can you help me with the interpretation of the term "the family"? It seems to me it's fairly crucial in this case, being
Well, the family can include just the individual. If one...
Well, the definition is page 21. It might be, as you say, it might just be the claimant. Then it says various other things, which I'm not sure I entirely understand the import of all of it.
I mean, my understanding of that is the family can be where the claimant is not a member of a family, it's just that claimant. If they are a member,
far is straightforward.
Yep.
But
And
what
if they are a
about
member,
the rest?
if they are a member of a family, it will be the claimant, their partner. There are some additional partners, and a person who has not attained the age of 19 and lives with the claimant or the claimant's partner. So it would be your usual understanding of a nuclear family, although
But it says for the purposes of state pension credit.
yes, I don't think that means only where you're dealing with state pension credit as the benefit from which there's a deduction being made. Yeah. So that is where one is dealing. Oh, I'm being told by my junior that in the ESA, the Employment and Sport Allowance, there is a definition of family, which includes, I think it's broadly the same as this. And it's intended, and it's certainly understood that it applies to that definition. So it's not just the claimant, him or herself.
So when the Secretary of State is exercising this power, they have to take into account not just the interests of the individual claimants, but also their broader family, including
Yes.
partners and children.
Yes. So, for instance, and we'll come on to talk about what this is, what the purpose of this is, but there may be a concern, for instance, that there are what's the impact on other members of the claimant may say, I don't want to have a deduction taken for my benefits because I want to be able to spend my benefit monies on whatever I like. But the question is, yes, but what's going to be the impact then on others if you don't start paying your fuel debt or your water debt and the ongoing usage of fuel and water? How will that impact on other members of the family? If you don't pay the debt, the utility provider may take you to court and get a judgment against you, which will impact on a whole variety of different things, which will impact on the interests of other family members and not just you.
There may be a whole range of interests of children and what they may need or want, which would be very difficult for the Secretary of State to know about, wouldn't they?
Well, the Secretary of State can certainly, the Secretary will assume, and there's references to that in the guidance, that they wish to avoid a disconnection of gas, for instance. Because if there's disconnection of gas, which is one of the alternatives options available to the
But not water.
gas provider, not for water, but for gas. That is one of the measures of enforcement. We're basically dealing with what are the alternative enforcement measures that would be available to the utility provider where a debt hasn't been paid and they're concerned about ongoing usage. There may be a concern about disconnection. There may be a concern that, well, they might put in a prepayment meter. And if they put in a prepayment meter, which there are exceptions in circumstances where that can't be done, as I know your lordships are aware, but where it can be done, there is a concern of what's known as self-disconnection, where there'll be a reluctance to feed the meter, which may impact on other family members.
Yeah.
So these are the kinds of matters that the Secretary of State is required to take into account.
But what if there are health concerns for children, for instance, that there may be a child might need some substantive and urgent, important dental work, and the family cannot find an NHS dentist, something in the news today, and says, look, for the next period, I don't want to pay my water bill. I want to pay for my child's dental work.
Well, the Secretary of State approaches this on the basis, as the judge found, that it will be in very rare cases where the TPD will not be in the interests of the family. Firstly,
You can ask them, can't you? You can say, can't you write to them and say, we're thinking of making a TPD.
Well,
Are there any reasons why we shouldn't?
Well, my lord, that's the heart of this case.
Yeah.
Yes.
I just wondering why you can't send a letter.
Well, one could send a letter, but the question is, are you required to send a letter? And that's what I'm seeking.
Well, because the statutory requirement, as I understand it, is that what you do is in the family's interests. And I
Yes.
don't see how can you know what's in any particular family's interests unless you ask them,
Because, my lord,
or at least give them the chance to tell you.
it will be in the very rare case, as the judge found below, which I agree with, and what my submissions agree with, that that a TPD will not be in the interests of the family. And I'll come on and address you on that, my lord. But
Well,
essentially,
as I understand it, that a family is never going to be cut off from water. There may be any number of things which they say is in the interests of this family and the children.
but they may not be cut off.
Which would be more beneficial to the family than paying a water bill, which isn't going to affect whether they have water or not.
No, but my lord, if they don't pay the water bill, and we get to this stage, and I'll take you through that. We only get to the TPD when attempts at alternative payments arrangements have failed. So this doesn't come out of the blue. It comes in circumstances where there's been discussion, communications, attempts to make alternative arrangements. If the TPD is not granted or it's not applied for, then the water company has a number of other options, including going to court to get a judgment and then seeking enforcement of that judgment. And the
family may have other judgments against them.
And the family may have other judgments against them.
So it may not be the biggest thing, the foremost thing on their mind.
But it may well be. And the fact is
Well, unless you ask them, you don't know.
Well, so my lord, the mechanism. So if I can move on to the next
Sorry, I'm
piece.
interrupting your flow.
No. But my lord, you're asking absolutely the right questions, and I'm happy to deal with those. But let me just explain the next part of the statutory scheme, and then see if that assists.
Yes.
Because the statutory scheme here has to be considered in the context of what mechanisms are available to the benefit claimant to deal with the decision to make a TPD. And not only are they not prevented from making contact with the Secretary of State in advance of the TPD, to say, we know that a TPD is about to be made because they've been notified of that by the utility provider. There's nothing to stop the individual benefit claimant from writing to the Secretary of State to say, please don't make the TPD because of the following circumstances, the dental treatment and so on. There's nothing to prevent them from doing that, firstly.
Seems a bit unrealistic, though. I mean,
Well, so
why wouldn't you, as the public body with the power and the obligation to consider what's in the best interest of this family, why would you not seek to obtain the relevant information from the claimant against whom you'll be making the order?
Because
simply write them a letter, say we're proposing to do this. Do you wish to say anything as to why it wouldn't be in the best interest of the family?
My lord,
and give them 7 or 14 days.
my lord, because there is a mechanism for dealing with decisions after they have been made,
But
which
why
will
not
effectively.
why not do it before then?
Well,
Why wait? Why wait? I mean, the point is, you've got to make a lawful decision. Why wait till you've made an unlawful decision before finding that out? Why not do it first?
Well, my lord, it's because you're not making an unlawful decision beforehand. You're making a lawful decision. If it's one that can be challenged, there is a process, and that process is a mandatory reconsideration or an appeal, a de novo appeal with no cost consequences to the first tier tribunal. And applying the analysis of the learned judge below, it will be the very rare case in which it wouldn't be in the interest of the family for there to be a TPD. The question is, does fairness in those circumstances, and I'll come on and deal with this, does fairness require in every case that the claimant has to be written to
There's
say,
been
is
a
there anything you wish to say?
proportionality to this, hasn't there? And at the moment, I don't really understand what the problem with writing the letter is. Well, you may say that
There is an impact on writing the letter, which is that it will delay the process by a period of time in which first of all, there will be TPD, there will be benefit claimants who want a TPD, and their want will be impacted by a period of weeks whilst the representations process has to take place. Because, my lord, you'll be envisaging a letter being sent out which says, write to us within 2 weeks or whatever, and then there has to be consideration. So there will be a period for every single claimant, and we're dealing here with hundreds of thousands of people a year. We're not dealing with a few individuals, we're dealing with hundreds of thousands. There will be a period of time, let's say it's 2 weeks, it might be longer, but let's say it's 2 weeks.
most of them won't respond.
No, but you still have to wait for the 2 weeks to expire before
So
you...
it's a 2-week delay.
So there's a 2-week delay, during which time the debt increases. Firstly, there will be some of the benefit claimants will want the TPD, so they're going to be held back from having their want put into effect. And secondly, everyone will have an increased debt over that 2-week period, which will therefore impact on other financial matters. It will mean it will take longer for their debt to be paid off. Whereas the TPD it crystallizes it basically stops the debt. It doesn't stop the debt from increasing, but it basically it deals with it will effectively deal with the ongoing usage, which is based on the average expected amount, and therefore will stop the debt from increasing. In your lordship scenario, there will be, let's say, 2 weeks of ongoing usage, which then just gets added to the debt. So there is a downside to benefit claimants in that process. The question of law here, my lord, is whether or not fairness dictates that in all cases claimants should be written to and given an opportunity to make representations.
You said a moment ago that claimants are not prevented from contacting the Secretary of State in advance because they will have been notified by the supplier that the application had been made.
Yes.
I've just, perhaps you can help me with where we find that in the judgment. I know there's an agreement, but I hadn't really picked up that was an obligation that the suppliers had undertaken.
254, 257, my lord, in the judgment. No, but my lord, I'm going to take you to the... You'll see, this is to do with water.
It's a bit mixed, yes.
Page 150. The interest party always, as a matter of course, notifies a customer of its intention to seek a TPD before the application is made. However, it appears that not all utility companies behave in the same way. The claimant's evidence is she was not told by E.ON that it was going to apply for a TPD later. The spreadsheets in use prior to December did not require a utility provider to inform the defendant that the claimant had been notified. The position has now changed, however.
Well, that's a matter of practice, but I didn't pick up any obligation on the supplier to do this.
So,
there's an
my lord,
obligation under one of the spreadsheets to notify the Secretary of State whether it had been done, but not an obligation to do it.
Well, but my lord, that is by definition the obligation to do it, because one has to notify the Secretary of State that it has been done. If that hasn't been done, then the Secretary of State will not make the TPD. There is if I can take you to a document in the supplementary bundle, I think it's page 11. This is part of what's called the joint statement of intent. Lord, the document starts at page 4 in the supplementary bundle. It says joint statement of intent on the DWP third-party deduction scheme in respect of fuel and water. And you can see this has been agreed by the DWP, the fuel suppliers licensed by Ofgem, and the water and sewerage companies. It describes the procedures for third-party deductions of fuel and water charges and so forth. And then at page 11 of this document, which is an annex, you can see with respect to, this is the application that is required to be made, and it's now reflected in the spreadsheet. You can see it's section 4, customer participation. Does the customer know that this application is being made? Yes, no, and then in brackets, if not, please tell them straight away.
Thank you.
So there is, and then the same, my lord, in respect of water, page 12, I think it's the last, second to last box, the same language.
And are they obliged to tell the customer how to contact the department?
That is not included in this.
So how are they how are the customers meant to know what to do? Well, if they want to make representations.
A customer who receives that and understands that a deduction is going to be made from their benefit, they are in regular communication, or they will have been in communication with the DWP in terms of receiving their benefits. They will have a number or a location of the relevant benefits office. They can access contact details on the internet. They will be in a position to consider, well, I don't think a TPD should be made in my case because of whatever circumstance there is. I will contact the DWP to say, please don't do this.
But they're not told that they can make.
They're not told that they can, but they're not told that they can't. And if they are, in the vast majority of cases, they won't have something to say. But those who do have something to say, the very rare cases, one would expect that in those circumstances they know how to contact the DWP. So that's so they know that there's going to be an application. So it doesn't come out of the blue. It's not the first time that they're hearing about it, and it's not just. And the application itself will have been preceded by a whole series of engagements with the utilities provider.
But they may have been told on the basis that it was a fait accompli.
I can't say.
We don't know what they're told.
I can't say what they're told. I mean, Mr. Koppel may be able to assist on that. But I mean, they are told we're applying for this. If they wish to make representations, there's nothing to preclude them. In a sense, they know the address to which they would need to make those representations.
See, I could see if it was said, if they were told by a utility company, we were making this application, which the Secretary of State will only grant if it considers it is in the interests of your family to make it, and you are of course entitled to make representations to the Secretary of State on that issue by email or post the following address. I could see there might be some force in saying that they're given proper notice of the issue and their right to make representations. But this isn't going to pass muster as any form of proper notice of their right to do so, is it?
Well, they're not told of their right to do so. I didn't put it as high as that, my lord. But they are told
or even what the test is.
Well, they're told what is going to happen. And my submission is they are on notice, therefore, of it, and they can, if they wish, and they're not precluded from doing so, make contact with the Secretary of State. What one has to consider here is the issue of, does fairness require that in circumstances which include all the pre-engagement, and then the fact that there is a process, a statutory process of mandatory reconsideration, and then a de novo appeal. And in circumstances where the extra period of time may cause hardship or detriment to large numbers of other claimants who have nothing to say. So, my lord,
Out of interest, when this document is sent to the department, what is the average turnaround? How long does it take the DWP to deal with an application?
my lord, I'll have to ask.
I just wonder whether
If I have an answer,
whether or not there isn't a 2-week slot during that period when they couldn't have written to the.
well, my lord, if my lord, I would ask the question and see what the answer. I don't know the answer.
It's all very well to say there'll be delay, but if the department takes several weeks to deal with this, then why couldn't they?
Well, but my lord, it might take, if it's taking several weeks to deal with it, it's on top of that, because if there are representations, they will obviously have to be dealt with, and then the question becomes that will.
No, but I think your point is that it will delay it in every case.
Yes, well, it will delay
whether representations are made or not.
It will delay it in every case because they can't trigger the deduction until that date has come when they either have the representations or they don't have the representations. Yeah. What I can't tell you is how long that period is in any event, but I can ask.
Is there any evidence about the purpose of the DWP ensuring that the claimant knows that this application is going to be made? In other words, why do they ask the energy companies whether they've told the claimant if it doesn't matter whether they have or haven't?
Well, my lord, it clearly matters whether they have or they haven't, which is why they have required it in the joint statement of intent, so that this doesn't come out of the blue.
Yeah, but why does it matter? What do they do with the information? They discover that they
well,
have been
if they
told.
discover that they haven't, then they won't make the TPD because they'll say they haven't been put on notice of it.
And so they discover that they have been told. And why does that play any part in the process? Why do they need to know that?
Because then they know that the claimant has been put on notice, and therefore
For what purpose though? Why put the claimant on notice?
But there could be various reasons to put on notice. One of which would be, well, then means if they wish to make representations, they can do. Nothing to stop that. It may mean that the benefit claimant will consider, well, there's going to be a deduction made from my benefit. I might need to make some other budgeting arrangements because I'm expecting that in whatever period of time is coming forward, that I'm going to have less coming into my account. So notice can provide two purposes. But my lords, what one needs to consider here, and the thrust of my submissions will be around: does fairness require it? Yes, is that a matter? Is that as a matter of law? And my submission is no. But I appreciate the points that you are putting forward. There is a mandatory reconsideration process. And that's set out at paragraphs 48 to 51 of the judgment. Mandatory reconsideration can have retrospective change. So if it's decided that it should not have been made, then it goes back to the original date. Or there is an appeal to the first tier tribunal. And as part of the mandatory reconsideration, the claimant can provide in a sense, whatever evidence they like, and they are not. They can set out, you know, these are the circumstances at the time that we wish that you had been aware of, as well as these are the circumstances that predated that.
How long does the reconsideration process take?
Yeah, I'm told that in the ESA, so the Employment and Support Allowance, when there were mandatory reconsiderations within that realm, not just dealing with this area, it's 47 days. It takes 47 days. In addition to mandatory reconsideration, as I said, there's an appeal de novo to the First Tribunal, and there's also a power to vary a TPD, what's known as supersession, where there's been a relevant change of circumstances. Now, as I've said, and as is set out in the judgment, before the TPD is called for, there is a process that the utility providers must go through, which include seeking to agree payment plans. And it's only when they fail that they will apply for a TPD. So it is likely that there will have been communications for some time about the usage, about the debt that's accruing, and so forth, and discussion with the individual claimant about their circumstances, because that will impact on the different plans that might be available. And if I just show you again in the supplemental bundle, that's page 184. This is, the document starts at 182. It's the standard conditions of gas supply license. And then there is a condition 27, picked up at 183, which is payment, security deposit, disconnections, and final bills. And you'll see there's, at the very bottom of 183, there's a heading Customers in Payment Difficulty. And then there is basically a process which is subject to the license, which is part of the license conditions for, here it's gas suppliers. The licensee must offer each of the services set out in paragraph 27.6 when it becomes aware or has reason to believe that a domestic customer is having or will have difficulty paying all or part of charges. The supply of gas. The services are to pay by using where available a means by which payments may be deducted at source, by regular instalments calculated in accordance with paragraph 27 and paid through a means other than a prepayment meter, so a payment plan, and then by using a prepayment meter where it is safe and reasonably practical to do so. And then, as well as provision of information about how one can reduce the supply. So these are the obligations. Then at 27.8, the licensee must take all reasonable steps to ascertain the ability to pay and must take this into account when calculating instalments, giving due consideration to relevant information provided by third parties where available, and where instalments were paid using prepayment means the value of all the charges. And then they've got to give due consideration to various matters, including making proactive contact with customers, which includes making early contact to identify whether a customer is in payment difficulty, regularly reviewing the methods, and so forth. And then understanding ability to pay is giving guidance and training to staff, etc., etc. So there is a license condition which obliges the utility provider to go through a whole process of communication, understanding information, before they'd even get to the TPD stage. And my lord, the evidence of what takes place with respect to water that was provided by the interested parties witness was accepted by the judge, and you'll see that at paragraphs 93 to 99, and that sets out in some detail, which I won't trouble you with, that whole process. And so these aren't things that happen straight away. There is a long prehistory to it. The information that is then presented to the Secretary of State is what you see set out in the spreadsheet. That was amended following the oral permission hearing in this case, as explained in the judgment at paragraphs 88 to 89. And my lord, you'll see in respect to the fuel company, which I think is the one with the orange, it's page 216. You'll see questions at the beginning. Has the customer failed 2 payment plans for this debt? Will enforcement action be taken if deductions are not made? Have you notified the customer? Any other relevant information? So the context, and that's the same for the water company at 217. So when a decision is made by the Secretary of State, they will know the information that's been populated on this spreadsheet.
So sorry, Mr. Sheldon, is this the new one?
That's the new one, my lord.
Post the permission hearing.
That was post the permission hearing.
And this is the old one.
That's the old one. There are two new ones, my lord. One is for fuel, one is for water. But the questions you see in the first few columns are the post-permission stage material.
Is there any significance to the colour coding in the boxes at the top?
Not that I'm aware of. No. And so the context in which a decision is made will be a failure to have achieved the payment plans. Enforcement action will be taken by the provider. The customer has been notified, and then there's a box for any other relevant information which they wish to provide. We've set out in our skeleton argument at paragraph 5 a series of propositions that we believe were common ground before the High Court. My learned friend, Miss Richards, has taken issue with some of those, but if I just take you through paragraph 5, that sets out the general background, that there's a detailed framework of guidance, so this is paragraph 5, for both utility providers and decision makers. Guidance and license conditions impose mandatory duties to carry out administrative checks and to contact the claimant and to exhaust all other debt repayment options before applying for a TPD. My learned friend said these aren't mandatory duties, but I've shown you the documentation which I suggest does make it an obligation on the part of the utility provider. There is a right to apply for mandatory reconsideration and de novo appeal, where a claimant can submit evidence not before the original decision maker, so they can provide any information that they like. when considering mandatory reconsideration, a decision maker can either revise the decision, change it from the original date, or supersede it, stop it from the date after it was first made effective. TPDs can only be taken if the claimant has accepted that the debt, either past debt or ongoing usage, is admitted. The decision maker would have information available from a spreadsheet or form provided by the utility supplier, plus the person's electronic records. And that's a reference to the witness statement of Claire Waterman that you have in the supplemental bundle at 167 to 168, where she describes at paragraph 46 to 47 information that would be available to the decision maker. And that means that the decision maker, either the initial decision maker or the decision maker at the mandatory reconsideration stage, has access to various information available to the department, which includes customers' health records, so they can identify if there is a particular health issue or flag that they may want to think about. And then there's a whole variety of other systems that they have access to, which may provide them with information about the other benefits that are being received and any material relating to that. So they'll have an idea of the general levels of income available to the benefit claimant.
Sorry, you gave a paragraph number there.
So it's 46 to 47, my lord.
Thank you.
Then, my lord, at F in the skeleton argument, the law changed after the claimant brought her challenge such that there is no power to make a TPD for debts for ongoing usage for fuel without a person's consent. And I think we've just drawn to your attention that that was initially a temporary regulation, now it's a permanent regulation. So in terms of going forward, not at the time of the challenge, but going forward, for ongoing usage for fuel, consent is required by all benefit claimants. Then in terms of the numbers, just under 200,000 TPDs for water from legacy benefits. And there's reference to the fact there were only 4 complaints. Because, again, not only is there the mandatory reconsideration and appeal, there was also a complaint system. And the fact that there were only 4 complaints, I suggest, is indicative of the fact that there is little concern with the way in which the system operates. My learned friend has challenged the point about the fact that TPDs can only be taken if the claimant has accepted the debt. She says, well, the respondent, this is not enforceable. But if the debt is disputed, that would be where the individual would apply to the Secretary of State for a mandatory reconsideration. You shouldn't have been taking this because I don't owe any money. And within the Social Security scheme, one would assume the decision maker can usually rely on a statement from the creditor that the debt is due. And my lord, there's a case in the authorities bundle which is called 1595. It's authorities at page 145 at paragraph 7. Commissioner Rowland, which says a decision maker can usually rely on a statement of a creditor as to whether there is a dispute as to debt. And in the overview document, at page 115, and these are, so there are 2 guidance documents available to the decision makers. At page 115, 4 and then 115. Paragraph 45 says, if the customer already has TPD for fuel and subsequently disputes liability for the debt, the DM should stop TPD until the debt is resolved, until the dispute is resolved. Then at H, my lord, there is a cap of the total amount that I've referred to that can be taken without consent. And this is 25% of the applicable amount, in this case of employment and support allowance, which might well not be, and it wasn't in this case, 25% of the total benefit entitlement to ESA, because ESA is made up of different component parts. It also, there may well be other benefits which the claimant is receiving, such as personal independence payment, housing benefit, discretionary housing payments, and so forth. And in the claimant's case, the total amount of TPDs for past debts and ongoing usage was around 5 to 9% of her total receipts from benefits. And the point to be derived from that is that there was money available to spend on other things, and we're dealing. The TPDs can only be up to 25% of a particular definition. And if I can just show you that in again in Ms. Waterman's statement at page 173, just to give you in the claimant's case what this meant. The paragraph 70, page 173. This is an update to the material that was in the summary grounds of resistance. The claimant currently has an ESA contributory and income-related award, including, and you'll see a whole series of benefits received from the Secretary of State, including a personal allowance. Well, that is something from which the TPD can be taken. But the personal independence payment is wholly disregarded. There is a severe disability premium. Yeah. That's part of the benefit from which a deduction can be made. The ESA support group payment, £39.40, they cannot take from that. So the 25% does not include that item. Enhanced disability premium, that is included within the applicable amount. And then there are other matters. And then at paragraph 71, there's reference to the other benefits outside of the DWP's responsibility, which the claimant was receiving. Now, my lord, those are the background facts, and I appreciate I've started to touch on some of my submissions, but I think it's important, at least that I can get across to you the background materials. There are a number of findings that the judge made, which not only do we not challenge, but those were the arguments below that we made that were accepted, and they're important as part of the analysis. Because one is considering not, is it possible for there to be a different system? The question is, does the law require it in those circumstances? And just looking at some of the key findings, at paragraph 179 of the judgment, the fact that other and less palatable means of enforcement are the alternative will mean, in the vast majority of cases, a TPD will be in the interests of the claimant. that, my lords, is in the context of what the learned judge said was the found was the statutory purpose. So, my lords, if we go back to paragraphs 57 and 58 in the judgment, the judge set out the statutory purpose, which was accepting our formulation. The purpose of a TPD, because...
Sorry, which paragraph?
So, paragraph 57, my lord.
Can you give me the page?
Page 102, my lord.
This is Miss Waterman's evidence.
No, sorry, my lord, I'm in the judgment.
Yes, I know, but I
Apologise.
think this is taken, isn't it?
Oh, it's taken from her evidence, but it's taken from the way we formulated it below. Yes. And the purpose is to ensure priority debts are paid where there is no dispute as to the existence and quantum of the underlying debt. To protect the welfare of claimants and their families by shielding them from potentially severe consequences of failing to address particular priority debts. This is achieved by paying a prescribed amount to a creditor to help remove the risk of hardship arising from potential enforcement action, for example, eviction, or the disconnection of a fuel supply, or a county court judgment, which could result in ineligibility to open a bank account, reduced credit rating, and other detriment. It is also preferable in most cases, in the context of electricity, to self-disconnection by a claimant not paying into a prepaid meter. And the judge added to the list of potentially severe consequences of failing to address priority debts the risk that the creditor might outsource the debt to a third-party debt collection agency and the stress that ongoing debt often engenders. So it's in that context that the decision to make TPDs are made. And then returning to later on in the analysis, so I showed you 179, the fact that other and less palatable means of enforcement of the alternative, meaning in the vast majority of cases, a TPD will be in the interests of the claimant. Similarly, at 194, my lords, in practice, however, it will be rare that a TPD would not be in the interests of the claimant.
194.
194.
The page reference?
Page 137. Sorry, my lord, 137.
It's just hard to move through
Yeah.
the electronic bundle.
I
and
apologise.
Page numbers.
Yes. Now, paragraph 173, my lord.
Forgive me, where the statutory purpose is stated, that all seems extremely sensible, but obviously the purpose is either to make a TPD or not to make one.
Yes.
And those statutory purposes are, it is to fulfil those purposes where it is in the interest of the family to do so.
The statutory purpose takes into account the language and that test, my lord, because it does presuppose that the interests of the family are, as the judge found, in almost all cases, going to be served by the making of the TPD.
Well, if that was the case, you wouldn't need the words "in the interest of the family" then, would you?
Well, my lord, the words are there, and in the...
Well, that must entail that in some circumstances it is not in the interest of the family to make the order.
Well, my lord,
Otherwise you wouldn't need the words.
Well, the judge accepted below, as part of his reasoning, that yes, there must be circumstances, otherwise Parliament wouldn't have included those words at all. However, given that the overall purpose of the scheme is as set out at paragraphs 57 and then 58, the judge was entitled to conclude, we say, that it will be in the very rare case that it won't be in the interest of the family. Now,
So the system, the scheme or purpose presupposes that it's in the interest of the family not to build up debt
yes.
to a supplier, even if looked at in some cases in the short term, it might be in the interest of the family to build up debt and to prioritise some other, let's say, urgent need.
Yes.
Yeah.
And obviously, there is an acceptance that there are certain debts which ought to be paid. I mean, that's why they're within the scheme. That's why we have housing. That's why we have fuel and so forth. That they haven't just been plucked out of nowhere. There would have been a statutory understanding that these are important, these are priority debts. If I can take you to paragraph 173, which is on page 134, which is in the context of prepayment meters. So page 134, paragraph 173. In the context of gas, I accept that it will almost always be in a claimant's interests to avoid having a prepayment meter installed at their property. This is because it gives rise to risk of feeding the meter and so forth. Consideration will only be given to the instalment of prepayment meters without a customer's consent if there's a history of being unable to pay their fuel bills. Paragraph 175, at the bottom of 134, it will very often be in a claimant's interest to be subject to a TPD because the alternative, other types of enforcement action are likely to be more onerous for them. TPDs are only sought when a customer has fallen into debt and attempts to agree a payment plan have been unsuccessful. And then at 176, legal action by the supplier will be worse for a customer than a TPD because it will give rise to additional costs. It's inherently stressful. It will adversely affect their credit rating and it gives rise to the risk of bankruptcy. All of these potential consequences are more unpleasant than a TPD, especially as the TPD does not go further than to require the claimant to pay debts that they owe and is capped at 25%. So, and this is in the context of arguments being made by the claimant that she had no fear of court action and so forth. Then, my lords, at the bottom of 135, there's an argument around, well, can't I just decide I don't want to pay? And the learned judge says that the 1987 regulations, so this is paragraph 181, must be interpreted and applied in accordance with their statutory purpose. Part of that statutory purpose is to provide a statutory mechanism which enables utility companies to recover, in appropriate cases, debts and ongoing charges, which would, absent a TPD, be irrecoverable. And it goes on, as the overview document noted at paragraph 3, part of the statutory purpose is to promote financial responsibility, and it would not be in the long-term interests of a claimant to reward them for ignoring or flouting their financial obligations or allow them to go ever deeper into debt.
Can I just ask about 178?
Yes, my lord.
Just one narrow question. The judge accepts that in the case of the claimant and a very limited number of other cases, the risk of legal action holds no fear. Can we determine from the judgment the basis on which he found that that was a very limited number of cases? Because the interested parties' evidence on this topic was that, as one would expect, they wouldn't pursue legal action against people who had no money, which I would have thought, a priori, would be a large proportion of this cohort. So I'm just interested to know what the evidential factual basis was for the finding that it would be a very limited number.
This will have been the basis of the evidence and arguments, where essentially the claimant was giving her circumstances as to why it held no fear for her, and the judge is making an inference from that, that is quite a rare situation. If one looks at the witness statement of the claimant, one can see it's a relatively extreme case. It's a relatively extreme circumstances.
She's not bothered
that she
about being
presents.
made bankrupt and so forth, but she doesn't think that she'll be sued because of her circumstances. But you must be right. I think it's just an inference. It's not.
It's an inference. I don't think
it can only be an inference.
it's an inference. It's an inference. But the judge goes on to say, well, even if they don't hold any fear, actually, it's not a good thing for this to happen. And
Because they're not going to give up anyway.
and also, one has to take into account, there's one thing that a claimant may take a view that I don't have much fear, but if they have a family, it's the impact that will have on the family, and obviously the stresses and strains of legal action are not only felt by the immediate party to it. So, my lords, against that background, I'm going to make submissions as to why the judge erred in law in concluding that fairness and or Tameside required there to be the further step that representations should be sought or further information obtained. So, my lords, the law with respect to fairness was summarised in the case of Doody, which you have in your authorities bundle. And the particular passage is at page 560 in the well-known statement sorry, I've got it in a different the case is at tab 22, starts at page 607. And it's 560 of the internal page. I apologise, it's 636 in your bundle. This is the judgment. This is in the speech of Lord Mustill. My lords, to the extent that you're not familiar with the case, it's a case concerning prisoners who received mandatory life sentences, were not informed about the recommendations of the judiciary as regards the length of their sentence. And the question for the court was whether or not they were required to be informed of the recommended length of sentence and allowed to make representations concerning it to the Home Secretary before any period of imprisonment could be determined. So, a very different...
Very old-fashioned flair.
Yes.
Flavour.
But the principles set out at page 560 have certainly come down through the ages.
Yes, I'm only talking about the facts.
Yes, but certainly the facts, my lord. And Lord Mustill says, and I'm going to pick up at little 5, fairness will very often require that a person who may be adversely affected by the decision will have an opportunity to make representations on his own behalf, either before the decision is taken with a view to producing a favourable result, or after it is taken, with a view to procuring its modification, or both. So the principle is that fairness often requires an opportunity to make representations, but not always in advance of the decision. It can include situations where representations are made thereafter.
Well, that's what it says, but this is looking at any administrative decision
Yes,
which may adversely affect a person.
absolutely. But that's a general it's a general principle.
Principle.
So starting from the general principle.
Yeah.
And then the question becomes, how do you apply that general principle to the present case? Now, my submission is that what fairness demands in any case is, as is said earlier in the judgment at paragraph 3, point 3, the principles of fairness demands is dependent on the context of the decision, and this is to be taken into account in all its aspects. An essential feature of the context is the statute which creates the discretion as regards both its language and the shape of the legal and administrative system within which the decision is taken. Now, that's why I've referred you earlier to the fact that within this scheme, there is not only is there the pre-engagement before the decision, but there is also the mandatory reconsideration provision and the appeal provisions.
Does the appeal point actually take it any further forward? Because given that there's a mandatory reconsideration.
No, it's just a further. It's just a further point where it may come.
Sorry, the appeal would apply. The appeal isn't the issue here. The point is whether or the complaint is that you don't seek representations
In advance.
in advance.
Yes. But the question is, but if you can have your representations made shortly thereafter and considered shortly thereafter,
Yes.
then that is relevant.
You say
defence.
that makes it fair.
That makes it fair.
I'm not sure that the existence of an appeal adds to that.
Well, it's a further reason why it makes it fair. Now, why an appeal? I mean, in this particular case, it may not make much of a difference because you've got the mandatory reconsideration, but there is a reference in the judge's judgment to confirmation bias, and one of the reasons that he said he couldn't rely on, or he shouldn't rely on mandatory reconsideration was because of confirmation bias. Now, that's one of the arguments I'm going to make, which is that he's wrong with respect to that, because mandatory reconsideration is a decision maker who is not bound by the material that was in front of the original decision maker, and so can be free and independent to make a fresh decision without feeling that they have to uphold what was said earlier. But the appeal would just add another layer to that, because you'll have a decision maker, a first-tier tribunal, which is entirely independent of the department.
If it takes you 47 days to reconsider, an appeal is going to take months.
Well, my lord, I accept that it will take a period of time. Yep,
I mean, I don't know how long the first-tier tribunal takes to get an appeal on, but it's going to be a long time.
Yeah. Well, my lord, I accept that it's not going to be a matter of weeks.
Inherently, it seems to me we're largely dealing with what are likely to be rather short-term issues, because I don't have any difficulty in the general principle that it is likely in cases that claimant should pay or be assisted in paying these important fundamental debts,
yes,
which they have incurred or continuing to incur in relation to heating and water, etc., or housing. The issues will be, it seems to me, whether it is appropriate to make an order now that benefits are immediately subject to deduction, when a claimant may have, at the moment, other urgent competing demands on funds, which anyone looking at it might say it's in the interests of this family at the moment for a period of time to pay to discharge those debts or to fund those requirements rather than to have the deductions to pay their water debt. And one can imagine a whole host of situations where that might arise. Somebody has the opportunity to go and interview for a new job in a far-flung part of the country, which is going to require them to travel and stay overnight or whatever, and they may need money to do that. That's something which a lot of people may say was in the interest of the family, that they should do that, rather than that money go to pay a long outstanding water bill.
But my lord, one is only paying a very small amount in terms of the debt, in terms of the water bill, but one is paying for the ongoing usage. So you're positing a situation where one can basically not pay what is due to be paid now, rather than something in the past, both the water and the fuel. My lord, the judge below sets out his answer to this at 184 to 186, and I rely on that. I'll ask you just to, if you read that, my lord. So I'm looking at paragraphs 184 to 186 on page 136.
Well, there are a number of different strands to this, aren't there? I mean, the autonomy point, for my part, I can see the force of what the judge says quite easily, partly because the statute is obviously taking power away from the individual in a wide range of situations. But it all rather begs the question of what's meant by the statutory words, the interests of the family. And the judge approaches this by reference to the purpose of the legislation. I would have thought it might be approached in a different way, by reference to what the words actually mean.
It is reading those words in the context of the surrounding framework.
Yes.
And that framework includes there are other debts, and perhaps I hadn't taken you to, but I took you to paragraph 8, which dealt with the aggregation of debts which can't go above 25% without consent. If you have several TPDs, so you might have one for housing costs, for instance, if you have several TPDs, there is then built within the regulations a hierarchy of which one must come first. Yeah. And that's what the judge here is referring to. He's essentially saying, and we agree, that the purpose of the scheme, and that's how you look at interests of the family within that, is that there's already a hierarchy of debts as preferences and so on. You can't seek to prioritise over and above that. And, my lord, it's in the context where we're dealing with only up to 25%. There is 75% of one's income from whatever benefit you have. That's the specified benefit. And there may well be premiums and so on top of that, which are not caught. And one may have other income or other benefits which are available to you. And the judge is essentially saying there that the fact that, to use my lordship's example, there might be a dental bill that needs to be paid, and one would like to spend money on that, or would felt a need to spend money on that. Well, that's where the 75% may be used if the TPD gets to the 25% level. The TPD may be well below 25% as well. But
Well, I'm not sure one can say that quite so easily, because the 75% will be required for things such as food.
yes, I appreciate that, my lord. But there may well be room within that for other things as well.
Well, there may.
And that
But isn't that exactly what would have to be considered potentially?
but my lord, the question is whether his lordship's finding is that it doesn't have to be. It's not part of the analysis, because the fact that you may decide that other debts are more important runs counter to the legislative purpose. They can't give preference to other financial obligations.
But isn't the point, someone's got to decide what is in this family's best interests, and you're saying the judge has found it's not the claimant, because that would be inimical to the scheme. So it must be for the Secretary of State to decide what's in this family's best interest. And the Secretary of State won't know that there's a child that needs urgent dental care unless somebody asks the claimant.
Well, firstly, it's it's interests, not best interests.
Yes.
One doesn't want to go there.
Does that make any difference? Does that?
No. It doesn't make a difference. I just want to make sure
No,
that
you're quite right.
whatever goes into any judgment doesn't include best interests, because that's not the test, and it has a relevance elsewhere. If the statutory scheme, properly understood, does not require that consideration as to other debts that may be owing, other financial obligations may be owing, as the judge found, then it's immaterial what the individual would have to say if they were given the opportunity, or if they took the opportunity.
I'm not sure that that's what this is saying, is it? This is all under the heading of claimants' desire for autonomy and for control of their own finances. I understand it to be, this is discounting the fact that the claimant may take a different view as to what she would want to do. I don't think this is saying that other debt, that the existence of other debts is irrelevant to consideration of what is in the...
My lord, I think this is how all the parties have read this, but if one reads it differently, the question is whether or not the process of post-decision representations, including mandatory reconsideration, which is a relatively swift process, is sufficient to allow for fairness, given that in the vast majority of cases there will be nothing to be said that could impact on interests of the family. My lord, you gave the example of the dental treatment. There will presumably be a payment plan which the individual would enter into if they don't. It's unlikely in the real world that if we're talking about hundreds of pounds or even thousands of pounds for dental treatment, that will be readily available to the individual. They will be entering into a payment plan with the private dental provider. So one has to look at it in that context, and then there, my lord, if in 47 days, and that's just the system as we know applying to ESA generally, provides for a decision which upholds the request for mandatory reconsideration, well then that will be addressed relatively swiftly, and only during an early part of the payment plan for that particular treatment. But the issue, my lord, ultimately is whether or not fairness requires in all cases the opportunity to make representations, even if there might be some cases where one would say they ought to have had an opportunity in advance, but that has to be weighed up against the overall process. Now, my Lord, coming back to the law, I referred you to Lord Mustill in Doody. That is the general statement of principle, which does include the fact that after decision representations can satisfy the test of fairness. So it is contemplated. And my Lord, the test that we suggest should be applied is one essentially just looks at all the facts and circumstances. It's not. There are no particular factors which are more determinative than others. But the way in which the judge looked at it was that he applied and regarded himself as being appropriate to apply the approach that Lord Justice Underhill took in the Balajigari case. And my submission below was that was, firstly, that was obiter, and secondly, that it wasn't consistent with the decision of the majority of their lordships in the Supreme Court in the case of Bank Mellat, and I'm going to make those arguments again today. But if I can just pick up the judgment at page 131, my Lord, but it's paragraph 161 and then through to 163, you'll see that His Lordship was dealing with the submission of my learned friend Miss Richards on a case called Balajigari, which is an immigration case, a question to do with indefinite leave to remain on the basis of an applicant's dishonesty or other reprehensible conduct, and whether or not the Secretary of State was required to give the individual an opportunity to respond before drawing a conclusion as to whether or not there had been such conduct. In the case, the Court of Appeal rejected the Secretary of State's submission that the fact that there was an administrative review process after the event meant that procedural fairness didn't require representations in advance. And Lord Justice Underhill set out as follows, that sometimes the duty to act fairly may not require a fair process to be followed before a decision is reached. That's duty. But he goes on to say fairness will usually require that to be done where that is feasible for practical and other reasons. Now, that, my submission, is wrong as a matter of principle. Lord Justice Underhill was able to make that statement because he relied on the judgment or the speech of Lord Neuberger in Bank Mellat, who essentially said the same thing. But I'll show you shortly that Lord Neuberger was speaking for himself in that case, and that the decision, the majority, 5 of the 9 judges, this was a 9-judge case, agreed with the approach taken by Lord Sumption, which was a much more, let's look at all the factors. But there was no particular focus on this, which is essentially a presumption that fairness will usually require that to be done where that is feasible for practical and other reasons, and I'll show you that. And you can see in the way it's quoted in this judgment, and if I took you to Balajigari, you'd see that as well. The next paragraph, paragraph 60, Lord Justice Underhill says, this leads to the proposition that unless the circumstances of a particular case make this impracticable, the ability to make representations only after a decision has been taken will usually be insufficient to satisfy the demands of common law procedural fairness. Now, my submission is actually on the facts of the case. That was obiter, because at paragraph 61, judge sets out why on this particular case the representations after the decision were not sufficient to satisfy fairness, because he says more fundamentally it is a central feature of the administrative review procedure, so the procedure that applied in this particular context, that the reviewer will not consider any evidence that was not before the original decision maker, except in certain specified cases broadly described as the correction of case working errors. So the administrative review process was lacking. It didn't allow individuals to say all the things that they would like to have said. That's
The claimant says that in this case that's what happened here, and that her representations were not taken into account after the decision.
No, my lord, on the facts here, the claimant was asked whether or not she wanted mandatory reconsideration, and she said no, because she wanted to challenge the entire scheme.
Well, I may have misunderstood what was in the appellant, the respondent's skeleton, but I thought they were saying that.
But my lord, what you need to be asking yourselves for this case, which is a policy challenge, which is basically whether or not the guidance is capable of being, or in a sense, is it capable of being lawfully performed? And the mandatory reconsideration process allows individuals to put forward whatever information they like, including material that was known to them at the time that the original decision maker made their decision. So here, if there were lots of things that didn't come before the original decision maker, the dental plan or whatever it is, then they would have an opportunity to raise it. Under administrative review, that couldn't be done. And that's why that limited type of legal review is clearly inadequate here. It is precisely because the applicant had no notice of the concerns that he or she had no opportunity to put evidence before the original decision maker. So, firstly, therefore, I say Balajigari was obiter. And you'll see at paragraph 163, that submission was not accepted by the learned judge. I take the view that I should follow this recent careful analysis of the law of the Court of Appeal, and moreover, I agree with it.
Well, you're not just simply saying, are you, that the Vice President's decision or reasoning was obiter? You're saying it was per incuriam.
Well, with respect to I am saying it's per incuriam. If per incuriam means you had the material in front of you, but you misunderstood it.
Bank Mellor, they didn't ignore Bank Mellor.
They didn't ignore it, and my understanding of per incuriam is if something is drawn to your attention, is not drawn to your attention. It was drawn to their attention. They just took the decision of Lord Neuberger as being the fundamental principle. So in a sense, I'm trying to assist Lord Justice Underhill by saying it's obiter, but he had Balajigari in front of him. He had Bank Mellor in front of him, he adopted the proposition in Lord Neuberger. I'll show you that in a moment.
Is it really your submission that that the Vice President was in fact bound to reach a different decision by Bank Mellor, and therefore we should not follow what he did, because we are also bound to follow the decision of the majority in Bank Mellor?
I'm not saying he was bound. He was bound to follow the majority decision in Bank Mellor as to what the principles were. But when he came to look at the particular facts, he concluded that the administrative review process, so when looking at fairness in the round, wouldn't satisfy the test of fairness because it was a limited power of review. So I can't say on the facts that he was wrong.
No, but so for two reasons. One, that it's obiter and the real decision is in paragraph 61.
Yes.
And secondly, because paragraph 60 is not only obiter but also inconsistent with the decision of the majority in Bank Mellor. That's what, and we're bound by that.
Yes.
That's how you're putting it.
That's how I'm putting the case. And not only did the judge here say that he was bound to follow it, he also agreed with it. And we see, in particular, at 216 in the judgment, is where the judge actually applies the guidance of Balajigari. Page 141, my lord, of the authorities bundle. Paragraph 216. I appreciate that there are safeguards built into the system and which come into play. So this is my point. A claimant can ask for mandatory reconsideration and can appeal. They can apply for supersession. They can avail themselves of the complaint scheme. But applying the guidance of the Court of Appeal in Ballyjagari, this is not enough to render the scheme fair. The claimant should have an opportunity to make representations before the decision is taken, not only to avoid confirmation bias affecting subsequent reviews reconsideration, but because many claimants will be close to the breadline, and if a deduction is wrongly made, a delay of even a few weeks could cause real hardship.
You say the confirmation bias point doesn't apply on the facts of this scheme.
It shouldn't apply where there's a mandatory reconsideration, no.
But that doesn't deal with the second and separate point that's made in paragraph 216, which could be said to be consideration of the particular factual circumstances in this case in accordance with the Bank-Mellach test.
In accordance with the approach taken by Lord Neuberger in Bank-Mellach. The test...
Well, no, I'm in accordance with Doody. Let's go back to Doody. It's a contextual, fact-specific, and indeed intuitive, in one respect, said in Doody, decision as to whether, in the particular circumstances, fairness is satisfied by a subsequent review opportunity.
Yes. I'm not disagreeing that that is a factor that the judge was entitled to take into account, because he also says earlier on that he also looked at all the facts and circumstances. But the point that I'm seeking to get across is that he was influenced by Ballyjagari, and that was an error of law. And I don't disagree that one should take that into account. The question is, that's one factor. And in the majority decision in Bank-Mellach, they take into account all factors and don't appear to apply any particular weight to one rather than another. And of course, hardship will be relevant. It is relevant in Bank-Mellach. But in and I'm happy to take you there now, just so you can see in that context what the situation is. But my submission is error of law. Ballyjagari is not, in terms of paragraph 60, ought not to be followed by this court because it's inconsistent with the majority in Bank-Mellach. It is therefore open to this court to carry out the exercise itself, and should do so in the broad duty sense, in line with the way in which Lord Sumption set it out in Bank-Mellach. If I can take you to Bank-Mellach. It's tab 10, page 149 in your bundle. You can see at 149, I think I've added up the number of judges correctly. Yeah, nine judge court. And my lords, this was the case involving the imposition of financial restrictions on a bank, an Iranian bank, under the Counter-Terrorism Act. And basically the order that was made prohibited all persons operating in the financial sector from basically doing business with them. And so one can see it was rightly described by Lord Sumption as a draconian power. So I'd say very far from the present circumstances. Lord Neuberger's speech begins at page 262 of your bundle, 161. Lord Neuberger refers at 178 to duty, to the 0.5 of Lord Mustard speech, and then at 179, in my view, and this is to do with post-decision representations, the rule is that before a statutory power is exercised, any person who foreseeably would be significantly detrimentally affected by the exercise should be given the opportunity to make representations in advance, unless the statutory provisions expressly or impliedly provide otherwise, or the circumstances in which the power is exercised would render it impossible, impractical, or pointless to afford such an opportunity. So that's the approach that Lord Neuberger takes, and that's what's picked up, as I said, by the Vice President in the Balajigari case.
I'm very sorry, Mr. I'm afraid I didn't catch the paragraph reference.
So, my Lord, it's 179. It's on page 266.
It's paragraph 179.
Paragraph 179.
I see, sorry.
Sorry. I mean, look, because in this report there are two judgments being set out. I think one is to do whether or not it should be open and closed, and then you've got Lord Neuberger dealing with this particular point at 179. Now, my Lord Sumption, the relevant, his judgment is at 212, page 212. It's paragraph 1 of the judgment. But this is the second judgment. This is the substantive judgment.
Sorry, page what?
So page 212 of the authorities bundle, but it's page 763 of the 2014 appeal cases.
Thank you.
And it's his judgment was agreed with by Baroness Hale, Lord Kerr and Lord Clark, and then I'll show you that Lord Dyson also agreed with it. But if you just take it, I'll show you that now, just to, and then we can get into the detail of it. At page 269 of the authorities bundle, paragraph 196. Page 820 of the appeal cases. Lord Dyson, I agree for the reasons given by Lord Sumption that the appeal should be allowed for the procedural issue. So that's 4 judges plus 1, that's the 5. And Lord Sumption doesn't make the same presumption as Lord Neuberger. It is a much more, it needs to look at everything. Matter is picked up at paragraph 28 on page 223 under the heading The Bank's Procedural Grounds. At paragraph 30, His Lordship sets out the duty formulation. And then at paragraph 31, it follows that unless the statute deals with the point, the question whether there is a duty of prior consultation cannot be answered in wholly general terms. It depends on the particular circumstances in which each directive is made. So it is a broad test. And then at paragraph 32, His Lordship sets out the reasons why on those circumstances, unless the Act there expressly or impliedly excluded any relevant duty of consultation, it is obvious that fairness required that they should have had an opportunity to make representations before the direction was made. First is to do with the impact, and that this was only focused on one company or potentially 2 companies, which is different from the regime that we're concerned with, which, yes, it does affect an individual, but it also affects hundreds of thousands. That's the administrative scheme. Secondly, it came into effect almost immediately. The number of people to be insulted was just one. It was a principle of good administration. And then at paragraph 33, it was argued that there was a right to make representations afterwards, and didn't that satisfy it? Firstly, there was a statutory right of recourse to the courts. And then there's a question about subordinate legislation, because that particular scheme involved secondary legislation. And his lordship deals with this really at paragraphs 35 to 37. Firstly, the fact that there is some form of procedure afterwards doesn't necessarily mean that the duty of fairness can only be exercised afterwards. But at paragraph 36, it does not follow, of course, that the duty of prior consultation will arise in every case. But then looking at the right to recourse to the courts, paragraph 37, section 63, which was a specific statutory right of review, largely reproduces the rights which a person affected would have anyway by way of judicial review. Just took out the permission stage, so that wasn't regarded as sufficient, and it wouldn't be sufficient to achieve fairness in every case because it's an immediate effect. The application is likely to require evidence on both sides. It's going to take, unlikely to be determined in less than 3 months. It may take even longer. In fact, it took 7 months. And this mattered particularly in that case because it was the exercise of a draconian power. And even if it was set aside, the impact on the goodwill may be substantial and in some cases irreversible. So that's not to say in the instant case that there's no hardship if a TPD is made, but it has to be seen in the context of the 75% that will be available, and if the decision is to reverse the TPD, we're not in the situation, or unlikely to be in the situation, where there will remain a substantial impact. So essentially, what one takes from this is it's a broad range of factors that should be taken into account, and one needs to look at all the circumstances.
Well, but one also takes from it basic principle that where there is a party is adversely affected by an administrative decision, basic principle of fairness requires that they be consulted.
Yes, but not before. My Lord, at paragraph 36, I just took you to, it does not, of course, follow that a duty of prior consultation will arise in every case.
Not in every case. But can I just ask 2 questions about analysis of this judgment and the supposed difference between Lord Newburger and Lord Sumption? I think it follows from your submission that the head note writer has got it wrong, and that Lord Newburger wrongly thought that he was in agreement with Lord Sumption. I say that because, let's start with Lord Newburger. At paragraph 162 on page 262 of the bundle,
Yes.
he headlines his conclusions by saying that in agreement with Lord Sumption, the procedural challenge succeeds. And then at 178, he cites what Lord Sumption has said at paragraphs 29 to 30, which we passed over, and interprets that as a duty to give prior notice. in circumstances such as those my lord has just indicated, where the executive proposes to exercise powers to the substantial detriment of the individual. Not an invariable duty, but as it were, it's always dangerous to say presumptive, but one which is more likely to be present than not. So that's Lord Newburgh seemingly believing that he is in agreement with Lord Sumption. And then if we go back to the head note, wherever that is, on page
151, my lord. Is it?
yes, it's quite a long head note.
Yep. So one.
This may be something you can come back to tomorrow. But 2 on page 151 of the bundle. This is head note 2 on the appeal. The partial dissenters are identified as Lords Hope, Reed, and Carnwath.
Yes.
And then the words that follow seem to be pretty much along the lines of what we've just seen in Lord Newburgh.
So, my lord, it's certainly possible to read the judgment as if Lord Newburgh agreed, certainly with the findings of Lord Sumption. The piece that is, in a sense, relevant for my argument is the relevance of paragraph 179, and that might simply be regarded as obiter by Lord Newburgh, which then gets picked up by the Vice President as the law, and then flows through into the individual case. So it may be that it's not necessary to go further than that. But there's certainly 179 is what features in Balajigari.
Sheldon, we really do have to stop now, as one member of the Constitution has commitments elsewhere. So shall we resume tomorrow
Yes.
at 10:30?
Yes.
You're due to finish by...
I think I'm 11:15. 11:15.
Yeah, you're on track to do that.
I'm on track to do that.
Thank you very much.
Authorised.